the federal requirements. As a benefit consultant and working with clients to design and manage their programs, we want to be sure that you're also in compliance with both state and federal laws. If employees have been on leave for less than 13 weeks, under federal health care reform, the employee must be brought back to work with no waiting period or the first of the month following, whichever is earlier. Next slide.
Along those same lines, Bonnie, does the Affordable Care Act still apply?
Yes, all components of the Affordable Care Act still apply. It is still the law of the land. And so as a small employer, and as I understand the participants on this call typically have less than 50 employees, you still have to distribute all the notices that you see here. The summary of benefits and coverages, which summarizes the benefits that you are providing to your employees. The exchange notice, which lets them know that the exchange is available as an alternative to their employer benefits. The COBRA general notice, which lets them know about their COBRA rights if your AOAO has 20 or more employees. A summary plan description, which describes when employees are eligible for benefits and when they're not eligible for benefits and their rights under the plan. And the Medicare notice of creditable coverage, which confirms that the drug plan that is offered by the AOAO to covered employees meets the minimum requirement as defined by Medicare.
So if employers are looking to change or reduce their benefit expenses, what should they be considering before making those changes?
So historically, employers have always been very generous in Hawaii. Where we see employers looking to in the very near future is really evaluating what benefits are most important. In the state of Hawaii, we do have to provide medical and drug coverage as well as statutory TDI. Benefits such as vision, dental, life insurance would be considered voluntary benefits, which the employer would not have to pay for. If you are making any changes to your medical or drug benefits under healthcare reform, you want to be sure to give the employees at least 60 days notice if this change is being made after you've renewed your contract with your health plan.
Do you have any advice, Bonnie, for employers who have employees enrolled in the Hawaii Health Exchange?
Yes, so if employees have enrolled in the healthcare exchange, their income may vary throughout the year as they are furloughed and they're brought back to work. So it's conceivable that they may be eligible for tax credits based on their income and then no longer be eligible for those tax credits if they're brought back to work full-time and incur a pay adjustment. So they should be sure that they're keeping good records so that they can respond accordingly at the end of the tax period. Thank you.
Thank you, Bonnie. Next up is Ron Sukamaki, consultant for Atlas's AOAO Specialty Unit. Ron has led our unit since 2007 and brings over 45 years of insurance industry experience to our team. He works with our group to manage over 300 condos and HOAs throughout the state. Ron, everyone is asking the same question. Does my insurance cover any claims related to COVID-19?
Thanks, Carol. And the short answer is we are treading in new territory for most insurance companies. I'm going to start with the property casualty side, and on the property side, we're seeing a lot of claims coming in from what we call business interruption, loss of revenue type exposures. And the short answer is most carriers are denying those type coverages, although there are several major lawsuits pending on the mainland that we're watching because depending upon the legal outcome, it could change some of the answers. But right now, most of the carriers are denying coverage for loss of revenue, business interruption type exposures. General liability, and liability is a whole new field in a sense that general liability meant to protect, provide coverage for bodily injury to third party as a result of negligence of the association. Now, does that mean the coronavirus is that bodily injury? And also, what is negligence of the association? And a lot of this is going to be up to the courts to decide. But we've talked to numerous carriers, insurance carriers, and obviously depending upon lawyers' interpretation, how they file the suits, there could possibly be coverage. I know that several carriers we talked to indicated that they would probably have to provide defense for the coverage and let the courts decide on whether the association was negligent. One area that we're really seeing a lot of activity on is in the directors and officers liability. What is the duties of the directors and officers to protect the unit owners, visitors, guests to exposure from the COVID virus? Certainly, this is going to be an interesting area. We're seeing a lot of carriers who are already talking about revising their coverage terms to exclude the coverage. But in the meantime, again, it's an area of law that we're going to see a lot of suits. But the D&O market has been hardening and in the last few years, and this certainly isn't going to help in the area of D&O.
Thanks, Ron.
Okay.
So many insureds have already been experiencing increases in their insurance premiums over the last year or two due to a hardening market. How is coronavirus impacting this market?
Well, it's certainly exacerbating already what I consider a pretty tough market situation. I've been in this business for a long time, and this is probably the third what I consider really hard or hardening marketplace that we've faced. And what does that mean? In a normal hardening market, it usually means prices go way up and capacity goes down. That means carriers are unwilling to take on more risk, and that's what we're seeing. So let's start with property. Property is probably leading the charge in a big change coming. All the major carriers in Hawaii are already relooking at their book. First Insurance is starting to get off a lot of their accounts because of prior loss history. And then you add on the potential of additional losses that they certainly never paid any premium for or charged any premium for, then you're seeing even making the market tougher. Directors and officers, I mentioned it earlier, but the D&O market for the last 3 years has been hardening just due to adverse Hawaii loss history. One of the major carriers had a 140% loss ratio year before last, and so they've really started to harden increase their premiums. But with this COVID situation, it's really bringing another scare into the market because it could be more suits. Therefore, you're going to see even tougher action by the insurance carriers and increases where maybe a 10 or 15% increase last year will now be a 20, 25% increase. So we're seeing that in D&O. Umbrella, we've seen what we call social inflation on the umbrella premiums just because of larger lawsuits countrywide. And now, with this potential of the COVID virus eating into general liability losses and claims, who knows what the claims can be, it's certainly going to put a lot more pressure on on the umbrella carriers to increase rates even further. So that is where we're really seeing a lot of problems. One of the things we haven't talked about is workers' compensation. Workers' compensation usually is a small part because most associations don't have a lot of employees. But with this coronavirus situation, workers' insurance carriers are really taking a close look at their coverage and recognizing that there will be potentially a lot more claims coming from people who say they've contracted this as a work-related injury and submitting claims. So workers' compensation, we anticipate next year we're going to start seeing a lot more increases because of that.
Thanks, Ron. So should insureds expect to see any new exclusions relating to COVID-19 on their renewals?
The answer certainly is yes. From our conversations with a lot of different insurance companies, they're all looking at their policies now, and they're looking at terms and conditions and areas where they could be sued, or potential areas where they think they could be sued under due to losses by the coronavirus. So all carriers are looking at their forms. I think you're definitely going to see what we call in the excess and surplus lines, like Lloyd's of London or some of those non-standard markets. You're definitely going to see more restrictive exclusions coming out. Lloyd's of London recently when we talked to some brokers into Lloyd's of London, they've indicated that they're going to start issuing exclusions for pandemics. So we're seeing that all the D&O carriers, again, are really worried about this. And so I think you're going to start seeing the directors and officers policies with exclusions for this.
Thank you, Ron. So now we're going to move on, and I'd like to introduce Kapono Kiakona as our next speaker. Kapono is a partner with the law firm of Porter McGuire Kiakona. Kapono has been practicing law for 18 years and has focused his practice on association law and all transactional legal matters that transpire with the governance of associations. This is Kapono, this nice picture before COVID-19 hit, and this is Kapono after COVID-19 and from working several months at home. Thanks for sharing, Kapono. We appreciate you being here.
Oh, thanks for having me. Oh.
Thanks. On a serious note, Kapono, please share with us some of your thoughts on how boards can potentially minimize their liability as they begin reopening their amenities.
So the first thing for boards to remember is that the key to liability, it's just showing that you didn't screw up. There's gonna be damage. There's gonna be people hurt. Things happen in life. You wanna put the association in the best position to show that you did what you needed to do. And the best way to do that is disclosures, right? Tell people what you're doing constantly. Have notices up around the common area, in the elevator. Tell them, look, we're cleaning on a regular basis. We're doing this, we're doing that. Disclose what's open within the community, what's closed. If you have an email blast, send reminders. You're gonna wanna be annoying to the point of people not wanting to read it anymore, but you have to keep track of it and you have to keep telling them this. What we have seen just as people walking around, I went to Maui this past weekend, and there are quite a few people still social distancing, but there's still some that walking around without masks and have no compunction about doing it. Those are the people that, if they cause a problem in your association, you want to have given them enough notification as to what's going on. You also want to get waivers for certain things. One of the common ones is for the gym, right? You get a waiver saying, look, if I get COVID, I won't sue the association. That doesn't stop people at all times, but it helps a lot. Talk to your counsel. Have them write it up. Anytime you're going to open something, think about it. Think about getting a waiver for it. See if it helps. See if it's something that's important. Some of you have already opened quite a few. You're jumping ahead on me?
Oh, no.
So some of you have already opened quite a few of the properties. Some have stayed open. What we've seen is that pools generally seem to be a safe one to open. You know, the articles I've read, and by all means, I'm no doctor, read your own stuff. They seem to indicate that transmission through use of the pool is relatively non-existent, provided people still provide your standard social distancing. Right? But you want to stagger those because you want to look at, okay, what's next? Maybe there's a community room we want to open. Maybe there's a gym. The gyms, as we've seen, are kind of last on the list just because people sweat, they breathe heavy, no one's going to want to wear a mask in the gym, things like that. You're going to want to augment your cleaning schedule. Right? You're going to want to do more cleaning. Public bathrooms, public areas, workout areas, movie theaters, if you have them. I know some associations or some buildings are saying, okay, we have this room that is always free for you guys to use, but now we're going to have to get a cleaning fee because we're going to get someone in as soon as it's done, and they're going to wipe it all down. You're going to want to remind your people to clean the common areas, and you're going to want to post about it. This goes to the reminders, where you say, as a reminder, we are cleaning twice a day of these common areas. Please ask us if you have any questions, things along those lines. With common areas that can accommodate people, and this goes to gyms generally, you know, you're going to want to limit your numbers. Right? It's pools and gyms. You can have sign-in sheets. You limit your numbers. You tell people, look, guys, let's all be adults here. Let's not have 40 people in the pool at one time. Let's be smart. Let's keep it to a minimum. You can trust. You have to, at some point, trust that people are going to make the right call. But part of your job is reminding them to make the right call. All right, now next slide.
Thank you. Complying with the shelter-at-home mandates, many projects were put on hold. Is there a good time to resume these projects?
You are definitely going to look at this on a case-by-case basis, right? Your first question we have already written down, look, can it wait? Really, can it wait? If it's something that's not absolutely necessary, maybe we wait on it. But as part of the can it wait, you say, all right, well, the second part of that question is it's essential, right? If it's essential, you want to push it forward, you need to move. But as a big part of that, also consider what the real contact is involved. If it's window cleaning, well, that's a very limited contact action by your vendors. If your vendors, if you have, say, one of the Kakako buildings, right, where it's just all windows, that seems like not that big an issue. So you want to look at it from the totality of the circumstance in that sense and say, look, it can wait, but also no one's going to be in contact with these guys. So maybe we do it. But more importantly, talk to your servicers, get in writing what they are doing to prevent contact, to minimize risk to their employees and your people, but mostly your people. You're not responsible for their employees. Make sure you get that in writing. That's the best way to get it done. Next.
Another question that keeps coming up is whether AOAOs have any obligation to notify other parties if they become aware that a resident tested positive for COVID-19.
Okay. So, yeah, that is the big question. That is a serious question, too. Now, we have as the second note that AOAOs aren't governed by HIPAA. I do want to clarify a little bit. For the most part, they're not, right? HIPAA is the Health Insurance Portability and Accountability Act. It's designed to apply primarily to healthcare providers and third-party servicers assisting in healthcare provision. Now, I've read some articles where people are suggesting that by demanding that owners provide you with information whether they are COVID positive or not, you're subjecting yourself to HIPAA. I think that's a gray area. With that in mind, you want to tell your residents, you want to warn them. You say, look, someone in the building's tested positive. But per their safety and their privacy, we're not going to identify the person or the unit owner. You're going to say, look, we're going to follow the CDC guidelines on cleaning and disinfecting. Right? Now, if the owner says, okay, you can tell them it's me, go ahead. That's not an issue. But with that in mind, the Department of Health is going to probably come in and do some contact tracing. They're going to find out where this owner got it, who they've dealt with, who they are. Right? The thing to keep in mind as well, sorry, I'm jumping all over the place on this one, but the thing to keep in mind on this is that the residents that is infected creates an infection within their unit. Anyone else who lives there, same lockdown, their same quarantine. It becomes a unit issue. So when this happens, you're going to want to be able to do certain things. You're going to definitely have them isolated for the most part. So you want to set up a schedule with the resident because they're going to have trash. So you're going to say, okay, look, leave your trash out at this point in time. We'll send someone by to come and dispose of it. Set the date, set the time. They'll likely have food delivered. You'll want to establish a way for them to get the food. Often it'll be, okay, this is what we're going to do. No contact drop off, set it up. A lot of food delivery companies are handling that on their own. The association may want to assist in that just to oversee it to make sure there is no significant issue that pops up from this. The other thing to consider is also keep in mind that you have employees that may be in a high-risk category. You're going to want to keep them away from these people, right? Keep them as far away as possible. Protect your employees. It's it is paramount in this instance because you know of a known risk and you want to keep them out of it. Next.
With some of the travel bans lifting and more people entering into Hawaii, what is the AOAO's responsibility for enforcing the 14-day quarantine period, whether it be legal vacation rentals or Hawaii residents returning home from the mainland?
So the short answer and the initial answer is one that we always keep in mind is the association is not the police. We're not the government. our jobs are relatively limited. So we don't really have responsibility because we're not responsible for monitoring all acts of all individuals. With that in mind, it's something you kind of want to keep track of anyway, because of the potential danger to all other people. What we've been talking about, well, what I've been talking about has been, look, you minimize your liability. If you have some visitor come in and you have absolutely zero protocols in place for the 14-day period, and someone gets sick based on that, then you may have an issue. Then you can't point to, well, we wiped it down and we did this and we did that, especially if there's some indication that, oh, well, they saw the guy going out with a surfboard twice a day and then coming back with Ala Moana packages within 2 days of getting here. So you have that issue. But keep in mind, it is a criminal act. I think they have some special division of the Attorney General's office, I believe. I saw on one of the websites. So call the cops. You know? Now, the thing is, this is a little different, not different. It may be harder to call the cops on your own residence, right? Some people are going to treat it differently. A tourist is a tourist, but you know, you want to keep track of your neighbor. You don't want to be calling the cops on your neighbor. So keep in mind that shame is a relatively good tool. You want to remind them in some way that, you know, you do this, we recognize you came back, we recognize you're under quarantine, please respect your owners, minimize any outside activity. There are certain things you can do, please stick just to those. We thank you. All right, next.
Lastly, we have a two-pronged question. First, does the AOAO have a legal duty to protect the residents? And if yes, can their employees be held liable or sued for not doing so?
Okay, so the association has your ordinary duty of care. It's not really a heightened duty of care. It's not the same as someone in their absolute care, like if I have a bigger duty to take care of my kids. I probably fail that more often than not, but such is life. They've made it this far. They're 13 and 11. I think I'm doing all. But as for the association, you know of a known danger. And that's the thing. When all of these things come out, the duty of care is what we've been explaining, and which, frankly, I'm sure I've stepped on his toes a little bit. Kevin's going to cover some of this as well, and I apologize to him if I've stole any of his thunder. But he's definitely going to go into greater detail. But the things we've been talking about and the things that Kevin will be talking about are absolutely the things that you are going to point to and say, look, we've met our duty of care. We've taken care of it. Now, are the employees liable for if they're not following the duty of care? Well, generally, yes, but they'll also be covered under your policy. So if you know of your employee doing dangerous things, you need to counsel them. Right? Now, you have no control over what they do on the weekends, right? Or whatever their days off are. They could be going to giant raging parties on the North Shore where no one's practicing social distancing and no one's wearing masks. But while they're at work, you can provide them with masks, or you can tell them bring their own, or bring the ones we've given you, wear them. You can't work if you're not wearing it, or things like that. You can implement sufficient rules to protect both the employee and the association from any lawsuit in the event that someone gets sick. And so with that in mind, I'm going to turn it over. And as I mentioned, Kevin's going to discuss in greater detail and probably much more importantly and more interestingly than what I talked about. So I turn it over now.
Thank you, Kapono. Our next speaker is Kevin Crawford, Risk Control Consultant for Atlas Insurance Agency. Kevin brings 6 years of industry experience to the Atlas team. Kevin will be sharing some best practices for safely reopening the amenities in your buildings.
Oh, thank you, Carol. I think we can move on to the next slide. We'll be sharing a few topics we felt would be beneficial in mitigating the COVID spread as you begin to reopen the amenities, reopen the property, establishing policies, and just maintaining the open status. We do realize not every property is the same. You got big ones, you got small ones, and you got the ones in between. There's countless topics that we could discuss, but we felt these topics would be pretty universal to serve as the basis of your operation. A few of the things we'll be discussing, or the topics we'll be discussing, is following directives, communicating, safe work practices for employees, common areas and amenities, and professional advice. Next slide, please. So if you Google COVID-19, there's tons and tons of information sites out there. A lot of it is good, a lot of it is very informative, a lot of it is not. So it's hard to find or hard to come up with an exact answer. And the best practice would probably be to follow the guidelines set forth by the Centers for Disease Control and Prevention, the federal government, state and local agencies. And these guidelines are rules to help mitigate or disrupt the spread of the COVID virus. And they're intended to be used by the population as a standard for everyday decision-making and preventative practices as we go out into the community. So since the virus is still new, these guidelines are based upon what is currently known about the virus, about its spread and the severity. So these guidelines really are a great resource for associations to use as they start to draft procedures, come up with house rules, and maintaining the operation as well. Next slide. So communication is something that is essential no matter what stage of the pandemic we're in. We heard Kapono say that it was something that's going to be a key element when it comes to liability. So since the beginning, there has been a lot of changes as to what we know about the virus. So it's a good way to remind everyone what the previous guidelines were, as well as what the current information is, and maybe where we're moving ahead throughout the pandemic. It's an excellent way to establish trust amongst your members by letting them know that you are taking the current pandemic seriously, and that the overall interest is safety amongst staff, members, and the property as well. Next slide. So the message should be consistent in that it should be consistent with what the CDC, federal, state, and local agencies are recommending. It should be consistent in that it should be done on a regular basis, perhaps having information come out every Monday. That will let people know that there is new information coming out and when it's coming out and when they should be expecting it. Through proper communication, you're likely to minimize confusion since we are in the stage of re-entering the economy or the community. Things are happening a little bit more quickly now. So people may not know what the latest rules are with regards to what they should be doing. And we can be honest, some people really are not going to take the time to research themselves to find out what they should be doing and how they should be doing it. As we heard Kapono say earlier, having a place where people can get information on the property, just a good old-fashioned bulletin board with posters. If you have access to an association website, it's a great source where you can post your information on there, or an email blast. The point is to have a centralized location or area where people can get this information, the facts about the virus, and again, maintaining that consistency with the base regulations set forth by the agencies. It'll give people an idea of what's currently open and what's closed and what you're doing to try to get to that open stage and what may be preventing you from getting to that open stage. I read an article recently that said, think of customers and clients as staff, as family. And the message I got from that basically was that you would not let your family go out to the community being misinformed or not informed at all. So one of the things you could probably take away from communication as we go away from this Is the moment you stop communicating, people are going to be more inclined to do what they want. Perhaps they're going to go out and don't see any kind of signage or mention of masks, so people might start loosening up. Maybe I don't wear a mask, I don't social distance. So communicating is going to be essential throughout the pandemic. Next slide. So a lot of what we've been hearing about lately has been geared towards customer or client safety as businesses start to reopen. But something we shouldn't forget about is the staff. Pretty common practice now, I believe, is temperature screening. I went for a haircut recently and filled out a questionnaire, just basic stuff. How am I feeling? Have I been in contact? Have I traveled? So just information like that would be essential in daily health checks. Right now is really a good time to encourage open communication with staff as we are moving into being back into the community. It is stressful. That way people are still confused on what to do. Another thing I thought of recently was to encourage staff to be honest with themselves. If they wake up in the morning and they don't feel 100% like they're ready to go to work, slight temperature, what's going to prevent them from taking something over the counter, ibuprofen, coming into work and meeting the temperature screening? So encourage honesty among employees. Another thing is training. Right now we assume that everybody knows exactly what to do or what the current situation is, but we shouldn't assume. So training staff on the facts of the virus. If they did come in contact with somebody, do they know the proper steps? Are they familiar with social distancing? All of that we assume everybody knows, but again, we really shouldn't assume that. Next slide. Providing hygiene stations, hand sanitization stations. Those are all over the place now. Who's going to be responsible for face coverings? Are they required to wear face masks throughout work, gloves, or whatever it may be? Another thing is to discourage, I know it may not be possible, but if it is feasible, discourage sharing of tools and equipment. And if so, if they do have to share, who's going to be responsible for that? Next slide.
Sorry.
No problem. So when deciding whether to reopen amenities, something you really should consider is if the pros outweigh the risk. If you manage a small association and you have the resources and tools to maintain that a fitness center is going to be open, you believe that your members are going to be in compliance with the rules, and it may not be too risky to open up something like that. Some associations may not have it in their budget to maintain an extra staff or hire somebody to clean. So in that scenario, the risk might outweigh the benefit in that scenario. Right now is really a good time to work with your staff and board members to identify high traffic areas like buttons, tables, door handles, faucets, and stuff like that. Another thing I thought of recently was trash. Abundance of trash, what is it going to bring? It's going to bring pests. What happens after pests come? Cats, dogs. And the CDC came out with updated information yesterday saying that the risk of transmission from an animal to a human is rare, but that also tells me that it is possible. And also another thing, how are these areas going to be maintained? Who's going to be responsible for that? Is it going to be the staff doing it on a regular basis? Is it going to be a contractor coming in to do it for you? Or are you going to rely on the trust of members coming in? Next slide. So aside from complete shutdown, social distancing is probably going to be the best solution for opening up communities. For instance, at a pool, you can remove equipment. At the fitness center, you can block off equipment to be in compliance with that social distancing. Reservation and scheduling, I believe that's going to be one of our new norms. We're already starting to see that with the large fitness centers. You have to make an appointment, schedule time. Also, opening these areas, are they going to be closed after a while so they can be provided with a deep cleaning afterwards? Is the amenity going to be open only for residents? Once we start seeing guests come in, it's the same thing with Hawaii. Once we start seeing guests come in, numbers are going to be going up a little bit after that. Next slide. Cleaning and disinfecting common areas. A lot of people don't know that there's a difference between cleaning and disinfecting. Cleaning would be soap and water to reduce the number of germs, followed by disinfecting would be actually killing the germ. And again, back to our communication, sharing the facts about the current situation on the virus. Next slide. So finally, seek professional advice. I know when we do open up, there may be some uncertainty about what should be open and liability concerns like we heard with Capono. And I do believe waivers are going to be something that's going to be very common for us as we move forward into the pandemic. Janitorial services. Is your staff fully trained? If you can't afford it, these janitorial companies can come in and train your staff for you. And another thing, in and out of a pandemic, safety really should be the highlight or the most important thing on property. Having somebody come in and identify those risks and what you might be exposed to as you do operate. Next slide. So some takeaways: follow directives when making decisions and preventative practices. Communicate rules and current facts. It's going to be essential. And employee well-being, common areas and amenities, maintaining guidelines and rules. And when you're uncertain, seek professional advice. Next slide. So we at Atlas Insurance, we do pride ourselves in thinking about what everybody wants. So we do have floor markers. If you are interested, please get in contact with Sean and let him know you want to place an order for floor markings. Thank you.
Thank you, Kevin. So I just wanted to remind everyone, we're about to get on to our last speaker, Keen Moranaka. And so I wanted to remind you, if you have any questions that you want to go over at the end of the webinar, please start to put them into the chat box at the top of the screen, and then we will gather them together and then address them best we can at the end of the webinar. So moving on, I'd like to introduce Keen Moranaka, Senior Claims Consultant for Atlas Insurance Agency. Keen has 25 plus years of claims management experience and has held various claims positions in the local property and casualty industry. Keen, sometimes there is confusion between the role of an agency claims consultant and how you work with our clients versus the role of the insurance carrier claims adjuster. Can you explain the difference?
Thanks, Carl. Let's see. As a claims consultant on the agency side, I advocate on the client's behalf. I advocate for you, the association. The adjuster really represents the carrier. And, the insurance adjuster may not always have a decision that the association feels comfortable with. But you may not know exactly what questions to ask the adjuster or what things to bring up. My job as your advocate is to ask the right questions and to push certain issues to try and get a more favorable position for you as the insured. What I do as your advocate is to analyze the claims decisions. This could be a decision on subrogation claim from that the association is trying to recover from another insurance carrier, or this could be a position on your own property or position from your own insurance carrier. What I look at is, was the decision correct based on the facts? Could I pose it differently or possibly provide additional facts or evidence to help with a more favorable decision? Because I work for the insurance carriers in the claim side for over 25 years, I can help the carrier see it differently and put it in words and terms that they are familiar with. This is the biggest benefit of having an Atlas claims advocate on your side. Next slide.
Thanks, Keen. So in Ron's section earlier, he mentioned that there could be claims that arise from COVID-19. Can you provide us with some examples of claims that you've encountered so far or scenarios that you've been questioned about?
The potential claims over the use of amenities is a common concern, and this is brought up in everybody's position, whether it's Pono and Kevin, even Ron had brought this up, but It's the potential use of the amenities is the common concern. A claim that I would anticipate from out-of-state owners is, why are the amenities, pools, gyms, picnic areas still closed? You know, I am losing income from my rental unit and I am going to sue the association. But on the flip side, you may have a resident that says, well, you know, why are the amenities open when COVID is still going strong? You're putting me, the resident, in danger, you know. As all of us said, you know, we would recommend that you consult with your association attorney to decide to either keep the amenities closed, or if it's time to open responsibly with a definitive plan to have safeguards in place to minimize potential exposures and claims. Follow CDC, state, and county guidelines. You know, potential allegations against the associations for not taking necessary precautions in the common areas. It's another potential. An example is a resident allegedly got COVID from someone who lives in the complex, and the association did not take the necessary precautions. And the association did nothing to protect the residents, allegedly. Can I make a claim against the association? Another example, a guest claims they got sick while staying in the complex. What do I do? Should I report it to my insurance company? The answer is yes. Please report these alleged claims to your insurance carrier to investigate and handle. The association should not make the determination if there is liability. They should not be becoming the insurance carrier. That is the carrier's job. Here's a question that I got from associations that have employees. Are my employees covered for COVID if they get it from work? What about an employee that was exposed to someone at work who tested positive or is thought to have COVID? The answer is, report it to your work comp carrier. They will do the investigation and look at the circumstances. They will also, you know, follow the state guidelines as to what is the contact tracing. You know, these, the lesson in all of these examples is to report it early so a meaningful investigation can be done while all the evidence is still available. Thank you, Carol.
Thank you, Keen. I did want to also add to your comments about really talking to your insurance agent. I mean, if you're ever in doubt, contact your insurance agent, talk about it. There are some coverages out there that are going to be timing issues with reporting. So as Keen said, the more proactive you can be and involving your consultants, the better it is for the AO and the board. Okay, so moving on, I'm going to just go over some key takeaways from each of the presenters. So Bonnie's section on employee benefits, key takeaways are: remember to comply with healthcare reform regulations. Premiums are expected to increase in 2021. And review your benefits. Consider a core buy-up approach. Ron's takeaways for the impact on insurance is monitor court rulings in other states, as Hawaii may follow. Pay attention to your renewals for additional exclusions and possible D&O, directors and officers, policy form changes. Bottom line, work with your insurance agent and ask these questions so you will not have any surprises. Kapono's key takeaways are: consider waivers, consistent communication, and remain vigilant. Kevin's takeaways are: follow directives, be consistent, communicate often, consider safe work practices for employees, maintain guidelines and rules, and seek professional advice. Okay, so now we're going to go through the question and answers portion. And I'm going to be punting it to various speakers here. So I'm going to start off with Kapono. One of the questions that has come in is, would the AOAO be able to impose stricter requirements? Example, continuing a quarantine.
Well, you have certain things that you can control, but continuing a quarantine is not one of them. I think that would probably fall under kidnapping. But I think what you may be able to do is certainly limit the activities around the property for people who are visiting. Now, you would want there to be at least some justification for it. It's not something you just do willy-nilly. But I would suggest not doing something that's very extensive, but maybe you can say, look, travelers, you got to wait an extra couple of days before we let you in the pool or we let you use the common elements.
Thank you. So I guess along that same lines, there's another question, Kapono. Are returning residents who are doing their 2-week quarantine permitted to leave their unit for any reason? What if they need to get essential items?
Yeah, it's mostly medical care is the exception, right? I'm sorry, I didn't double check on this one. My recollection was that it was just medical care, but I would have to double check on that. I would have to reread the supplement. My apologies.
Okay, well, we'll follow up. Whoever asked that question, we're going to have some contact information at the end. And so you can resend it to us and we'll make sure to get you a formal response to that. Since I'm on you, Kapono, there is a couple other more legal questions. One is, can the board mandate the use of masks in all common areas? And are we able to impose fines on unit owners or residents who break social distancing or quarantine?
Mandating is always difficult, right? I always talk to all associations in the context of, I can make the rule that everyone in my office has to be nice to each other, but I can't enforce that. So we have to be realistic in what we're saying. We have to say, yes, you are required to do this. Now, enforcement's a different animal. Most of your notices that we're recommending will say, remember to social distance. You are required to social distance per state law. So you have that. With the fining, it's difficult to do because you want your association to follow the proper procedures in changing rules, right? Especially when it comes to fining. So if you're going to have a fining procedure, you need a rule that it is specifically tied to. Now, arguably, you could probably go along the route of, you're required to follow all laws require you to social distance or wear masks, things like that. But I don't recommend immediately fining. If you want to fine, go through the process you would normally go through to amend your house rules to include whatever you're looking to fine someone for. I think that's
Great,
it.
thank you. And then lastly, Kapono, there's a few others with some of the other presenters, but for legal, the last question we have here is, are we able to hold annual meetings and vote by using a virtual meeting platform?
Okay, so that's an interesting position, and it has been difficult to press on. So with AOAOs, I'm going to separate AOAOs and community associations. So first answer, check your project docs, right? If you have the ability to do it, perfect. Often you don't. Often it doesn't say that specifically. Now, with AOAOs, there are certain provisions that say you can do it within the state as set by the board for whatever is most convenient. Arguably, a virtual space is both in the state and nowhere. So there are ways to at least justify it that I think support the ability of the association to defend in the event someone claims that it was improper. So the short answer is ask your attorney individually, but there are vehicles for them to walk you through it and to look at your project docs and look at the law and craft a way of doing it. Just as a warning for everyone, Roberts, if it's required to be run by Roberts Rules specifically doesn't want you to do online meetings. So when your attorney is working on this with you, they're going to look at what is the overriding provisions, if there are ways around it using 514B and using the project documents, which supersede Robert's rules in that instance.
Great, thank you. So Keen, there's a question on, would our insurance policy cover outrageous allegations of not preventing COVID-19?
You know, that's you know, one that the carrier is going to have to answer, because they're going to have to look at the allegations, you know, what goes behind the allegation. They're going to look at also what is the injury or damage that the claimant can prove. So the association's policy will have to look at all those factors in order to determine coverage, you know, and liability. So it's that's going to be a real gray area right now.
Right. So the best thing is just to put it in and let the carrier do the investigation, right?
Right. So exactly what I said in the presentation is, you know, report it to the carrier and let them do the investigation while the evidence is still available. You know, you don't want the evidence to disappear or witnesses to become, you know, unavailable, you know, should you want to ask those questions and get it done early.
Thank you. Few more questions, guys. The next one, since it's along similar lines, goes to Ron Sukumaki. Would the AOAO's D&O policy cover claims of negligence in preventing the spread of COVID-19?
Well, the short answer is possibly. You got to remember the D&O policies are there to protect the directors and officers for their fiduciary responsibility on behalf of the association. So, are they liable? Well, that's one of the questions the D&O carriers are looking at really carefully. And as I indicated earlier, I think you're going to see a whole round of D&O carriers putting exclusions in for any kind of suits from pandemic type situations. But right now, it's questionable. I think, truthfully, a good lawyer worded correctly, it could fall under a D&O policy if they deem that the directors and officers didn't do their fiduciary duty to protect people from the virus.
Thanks, Ron. So Kevin, there's a few safety related questions. How often do we have to disinfect high touch areas? Would our cleaning logs ever be inspected if someone accuses the AOAO of not doing enough to sanitize high touch areas?
That's something that the CDC came out with the rule for cleaning and disinfecting. However, it doesn't tell you how often you should be doing it. And I think the reason why is just because there's too many places that are being used at once, several times. And there's areas that are hardly ever used. So I think it's one of those things where you have to use your best judgment and your discretion. And for something like that, you can probably inquire with some of the cleaning companies on how often they would suggest doing something like that. But yeah, it's one of those things I think you have to use your best judgment for your situation that you're in and how much as it being used.
Okay, thank you. So another question along the safety area is, does leaving the trash room door open, is that a viable choice for minimizing touch points in a condo building?
I think that's something that probably can be practiced. Just the idea of minimizing the community touching certain areas. I think that's probably something that would be good. And it's also good for the idea of keeping a good flow of ventilation going through the facility at that.
Okay. And there's a question about barbecue common areas. You know, I guess the question is it better to have, you know, minimize the amount of barbecues open? So would one be better than having two so that they can kind of schedule it? Is there any recommendation, you know, from you, Kevin, or Capono on, I guess, how they should look at these kind of things?
I think this is something that falls under maybe the scheduling of amenity usage, scheduling and cleaning and disinfecting. Of course, maintaining a limited amount of people is probably the best way. So I would think something like that would probably fall into a place like this.
Right. Because they're prepping, I mean, cooking food, is there any specific concern about, you know, because I know Capono, you had mentioned about prioritizing based on, you know, level of exposure. I mean, would that be considered a higher exposure piece of equipment to open up in the common areas?
I don't know that it necessarily is, especially if you have someone sort of regularly walking by and wiping down. The idea is people are just cooking. They're not going to be, hopefully not eating right there and drooling all over the place.
Okay.
Hey, Carol, this is
Yes.
Vince.
Go ahead, Ben.
Yeah, I just wanted to add that what they might want to do is schedule it in between the usage. So you're just giving your staff time to come in and clean the area before the next family or guest comes in to use the area. Just a kind of a standard practice that some of the gyms are doing, but you could also apply it in the barbecue areas.
Okay, thank you.
Yeah.
So another question that's come through, and I think maybe this is more of a safety risk control, is there a standardized signage that they can access for COVID-related issues? I guess they're looking for particular resources to go to.
I think the best information would probably be to get from the Center for Disease Control and Prevention. It's probably going to be the best way, or the Department of Public Health through the state.
And just to add to that, if you go to the CDC website, they do have free posters that you can print out, probably 11 by 17 that you can actually print out and utilize. And they have it pretty much for all the different various areas related to COVID-19.
Great. Okay, so, Bonnie, or I guess Capono, the question came out, what can an association do about an employee that is fearful of doing their work responsibilities due to possible contracting of the COVID-19? Are disciplinary actions reasonable?
Yeah, you're going to hate me for this, but straight attorney answer, that depends. It's really going to be situationally specific. Certainly, if you've done everything you can to minimize their actions and you have no active cases within the building, then I think you may have to, and they're refusing to come to work, then I think you have a position to take. But you're also going to want to talk to your, as an association attorney, we tend to pass off the employee relations stuff because it is such a specialized subset. So absolutely, you're going to want to get in touch with your employment attorney to get the right way to do this to make sure that there is not something protecting the employee that I'm not aware of.
Thank you. Kapono, since you're the last one to answer, there's another question that's coming up. It's some Trans-Pacific arrivals have shown a letter from the Department of Defense stating they are exempt from quarantine. Another arrival showed an email from COVID-19exemption.com. How are we supposed to know what paperwork is legitimate?
Yeah, that's tough because I see this as sort of, as we've all experienced, the comfort animal thing where people just get vests and say, oh, my dog does something special for me so I can take it on the plane. That being said, if you're pretty sure the guy works for the government and they've got a DOD thing, great. You can take it at face value, right? The feds can overrule the state. If you got something from the federal and state government that says, hey, this guy can go to work or this guy can do this, they're exempt for X, Y, and Z, they're exempt. That's, you know, because what'll happen is you'll call the police will come and they'll say, they'll show them the letter and the police will ask you, why are you wasting our time? So that being said, if the guy looks unfortunately like me and is stumbling around all over and says, I work for the Department of Defense, then maybe you want to question it.
Thank you. And then I guess back to another question on the barbecue. It says no night staff to perform barbecue duties. So in that case, then I guess the question is, should we close the barbecue area? Vince, do you want to take that, or Kevin?
Carol? Hello?
Hello?
Yeah.
So I would think something like that would be for the association to make the decision. I am a kind of a cautious person. So if you can't be in compliance with what the suggestions are that were set forth by the CDC, I would probably err on the side of caution in that situation.
Okay, I think that kind of wraps up. I was just trying to ask those around me if there were any other questions that have come through, but I think we've gotten to most of them.
Carol, I wanted, this is Keen, I just wanted to point out just a clarification on that trash chute and trash area, leaving the door open. Be sure, you know, the association should check with the fire code and what is, you know, what they need to do, because I don't think that the trash chute was made to leave the door open in case there is a fire in the system. You know, they would want that to be closed for venting purposes. So that's something to stay away from. The other issue on the sign-off sheets to, you know, have like logs, I think that would be a good idea. I think the insurance carrier would recommend that they do keep logs of cleaning times so that they can show that, you know, the association did everything reasonably possible to prevent that COVID issue.
Okay, thanks, Keen. Sorry, just as I was kind of wrapping it up, a couple more questions have come in. One of the questions, and you know, whoever feels comfortable answering it, please speak up. It basically, if there is a unit emergency issue, are we able to enter a unit where the residents are in quarantine?
I guess I'll jump in. Again, it's going to depend, right? If there's a fire, that's an easy one. If it's, you know, you really got to look and say, okay, what are our options on this? You're going to want to push it off as much as possible. You're going to want to do everything you can to avoid sending someone in there in those 2 weeks. So it's, yeah, that's really, it's going to depend on what it is. Like if their fridge goes out, you're going to say, okay, well, maybe we can have someone in, but we're going to have to warn them. I don't think anyone's going to want to deliver a fridge to a place that's under COVID quarantine. So it's unfortunately a case by case issue.
Okay, thanks, Kapono. Let's see, a couple other questions. Good, I mean, great audience, guys. Thank you for, continuing to ask questions. One of the ones that have come in says, is it better to leave a door open for more ventilation in a gym or just keep the AC on with the door closed? Vince, Kevin, do you have any comments on that one?
I think it really depends on the ventilation system. So it's kind of difficult to answer just for every specific gym. But I do know that some gyms have been, that's one of the areas that they have utilized or as part of their controls. Of course, it's more than just the opening of the door. You have other social distancing protocols and cleaning and disinfecting, but you could consider doing that to improve the ventilation. But again, it really depends on the ventilation system in the gym. But that has been utilized for some businesses as part of their controls.
Okay. So another question about amenity areas is that one association has been waiting for months to get sanitizing stations. Are we still allowed to open our amenities if we give notice to the guests that they should bring their own wipes and hand sanitizers?
We're in the same situation at our office. We're waiting for our sanitization stations. And so what we've done is created some areas or portable areas where we created our own sanitization stations. So you still can do it. I'm not sure if you want to rely on just your guests in bringing their own, but you can create your own by providing wipes and hand sanitizers that's purchased by the at various locations. I did notice that there has been an increase in, or it's easier to obtain these products now. So my suggestion is to create some portable sanitization type of stations before your official stations come in.
Okay, thank you, Vince. Kapono, I think this one's a little related to what you were talking about. If the association does have knowledge that a resident has COVID, so it pretty much is just asking that question. What is the liability if they become aware that a resident has COVID?
Well, the liability is there if you do absolutely nothing, right? If you lay out the things that I briefly touched on and then that Kevin talked about, if you do what you're supposed to do, then look, anyone can sue at any time, but you have done everything to put yourself in the best position to provide a very strong defense, right? We've told them they have to stay inside. We haven't allowed them out. We've put in these rules. You've done what you can. So if you do nothing, you're probably going to be liable. If you do absolutely nothing, yeah, liability is probably significant.
Okay, thank you. A question was asked about whether the webinar is being recorded and will it be available. That is, yes, the answer is yes. We will be providing the recorded webinar to all of the participants today. I think that concludes our questions. If for whatever reason we did not get to yours or it was missed in some fashion, please feel free to contact us directly. I'm going to go to that page. You will get this as well. These are just some of our team members. They can be utilized to field any questions to many of us who have been a part of today's webinar. So just wanted to make sure we gave you that, and wanted to thank everyone for attending, and we appreciate you taking time out of your busy day to be with us. We hope this was helpful. Please feel free to reach out to us, and again, we will be sending you a link to the recorded seminar. Thank you to all the participants for the speakers as well.